Law Talk with Nick Maruchak, thanks to MKI Legal, your trusted employment and family lawyers.
Nick Maruchak is back in the studio ready to take your calls, 1338 882. A nice little holiday offshore in Southeast Asia. Nick, how did you go?
Yes, Bowie, it was great. Just went to Bali, good old Bali. Lovely weather, lovely people.
Seminyak, Legian, Kuta,
yeah,
one of the islands. Where'd you go?
Yeah, a couple of the islands as well.
Yeah.
So they were great, and a little bit, I just loved it. So it was good just to take time off.
Mate's birthday?
Yeah, mate, a friend turned 37, so, just me and a few of the guys went, no wife and kids.
37?
Yeah.
A landmark.
Yeah.
The old 37 birthday.
Any excuse, so.
Oh, yeah, for sure. If you'd like to speak to Nick, you can, 1338 882. This is extraordinary, this story. So a bloke was jailed by, I'll get you to explain it, but this is a family court decision, and a guy, a bloke was jailed, but then it was being overturned, and he sued the judge. Tell us about it.
Big drama in legal circles, and the High Court handed down a decision yesterday, quite important. So basically there was a bloke involved in family court proceedings, and he wasn't providing disclosure to the other side, which means he wasn't being full and frank with how much money he earned and providing the documents. So this judge did something very extraordinary. He sent him to jail for 12 months, right? And then the guy was in jail for about 7 days, and then another higher court overturned it and said, no, that's too harsh. There was an error there. When the bloke was in jail, he got raped, threatened of rape, he got assaulted. It was quite stressing. So then he sued the judge. He sued the judge personally for this wrongful conviction, and initially he won. He initially got over $300,000 in damages, and this sent the whole legal fraternity in a tailspin because judges have immunity, right? And everyone was like, well, you can sue judges now. That's crazy. But then yesterday, the High Court handed down a decision and said, look, that was wrong. Judges do have immunity, and this bloke ended up with nothing. So even though he was, he went through a pretty harsh experience. So it really highlights.
Is he out of jail, Nick?
Yeah, only 7 days in jail. So yeah, he's definitely out. So what he's hoping for now, he's gunning for a ex gratia payment from the Commonwealth Government, because when you get wrongful convictions in Australia, the only state that has a law that gives you money for wrongful convictions is the ACT. Every other state, the Commonwealth doesn't have it, right? Even though there's international treaties that Australia kind of has agreed to some extent, but hasn't implemented, that people should get money for wrongful convictions. But at the moment, his next step would be trying to get a voluntary payment from the government. And, some of these payments, like in the past, just, I don't know if you kind of remember, like Andrew Mallard, he got $3.25 million for 12 years.
Mr. Button.
Yeah, Button got $400K for a decade. You got Lindy Chamberlain, $1.3 million for 3 years. But there's also some interesting awards as well for people in jail for a very short period of time as well. So, some people who spent a few hours in jail got 20 grand. Bloke spent 56 days got 75 grand, and someone spent 3 hours got 25 grand. So that's kind of.
So Nick, is it at the behest of the local Attorney General in any jurisdiction? So it's up to John Quigley or whoever's in the chair at the time to make that payment?
Yeah, so this is the federal system, so it'll be the federal Attorney General to go up. You apply to them, and they have some criteria and to assess, and they will assess it. But they'll get, I don't expect he'll get $300,000, right? $300,000 a court will awarded him, and it's really up to the government.
For 7 days.
Yeah, 7 days. And the worst, a threat of rape is probably, traumatic, but it's probably not $300,000 worth.
Yeah, all right. Amazing that we don't have sort of etched in stone legislation or conventional policy around this. It's always at the behest of the Attorney General's goodwill, I guess, and ex gratia payment.
That's right, and it's uncertain, and they can always say no. And so, I think if we did have something, it would be it would really give public confidence in the system that if a judge goes a little bit rogue or does the wrong thing, there is recourse there. And I think it's it's a human right as well to if someone's incarcerated wrongfully, that's one of our breaches of fundamental freedoms. And international treaties really do say that you should award someone compensation.
If you'd like to ring in, you can, 1338 882. Have a chat to Nick Maruchak. He's here until 11 o'clock from MKI Legal, mainly family law firm, MKI, but Nick's happy to talk to you about any legal issues that might be on your mind today. So give us a shout while the phone lines are open. The perennial favourite with our listeners is having a dispute with your neighbour over a fence or a verge or a border. Tell us about this Peppermint Grove one.
So look, another big kind of case going through this dispute. There is basically some very rich people in Peppermint Grove, and they're fighting over a 135 millimetre slither of land, and the judge described it as hardly wide enough to accommodate a punnet of petunias. So very small land, but probably worth a lot, right?
Yep.
So what happened is basically, and this is something a kind of lesson for a lot of people here, is one of the neighbours built a wall or a fence encroaching in the neighbour's land, right? And now that the other neighbour is suing them. So one of the arguments here is that there is something at law known as adverse possession. So if you hold land for 12 years, you can keep it. So the argument here is whether the person who built the fence, they've held the land more than 12 years, can they keep it? So and this is what's going on, right? So they're having this big fight, and I don't know how much 1.3 centimetres of land in Peppermint Grove would be worth, but probably a chunk of change.
Yep.
But this is the kind of lesson for everyone. It's like if your fence is on your neighbour's boundary, and it's been there for more than 12 years, then you have potentially the right to keep that land, because this law as a possession really says that. You want the idea behind the law is that we want land to be utilised, right? So, and so that's something interesting. So it's really like a lesson for everyone to kind of check your boundary, get a surveyed, check your boundary fence, and if you think you have kind of occupied, someone's land, you can just go to Landgate, make an application, and they'll advertise it, and then you get it approved, or if it's disputed, it will go to the Supreme Court. But
So I wonder what 12 years how that became the line in the sand, so to speak. I wonder 12 years came from.
Yeah.
10 or 15 or 20.
Yeah, kind of 12 years is right, the limitation period for equitable claims. So, which means that it's probably the longest limitation period to sue someone. You normally, most claims are 6 years, but when it comes to claims for land, it's usually 12 years. So, so 12 years is if you're suing anything for recovering of land or anything like that, the 12-year mark.
Yeah, all right, let's take a call. Mark's phoned in. Have a chat to Nick. G'day, Mark.
Hello there. How are you?
Yeah, very well, mate. How can we help?
I have a question for Nick. I'll just give him a little bit of background. I had a problem with my oven about 3 or 4 months ago, and the guy came out, fixed it, and put a new part in, and the part had a warranty for 12 months. And lo and behold, 3 or 4 weeks ago, the part failed again. It's actually an oven element. And he came out, he put the part in at no extra charge, but then he charged me for the labour. So I've got a bill, and I'm wondering, should I pay it or not? Or I would have thought labour was included as part of the warranty. So that's my question for Nick.
Yeah, so this is covered under Australian consumer law. So basically, if you buy something, there is a reasonable expectation that this good will last a period of time, right? So I don't know how long an oven should last. My guess is that most people expect it to last 10 to 15 years, right? And if it's a more expensive one, probably a lot longer. So during this comes automatically with every good you purchase. It can't be contracted out of, right? So if the oven breaks, right, before a reasonable period of time, then the manufacturer or the seller has to repair it at no cost. So this case is they shouldn't have charged Mark for labour here. They should have paid the entire thing themselves.
Mark, was the second visit outside the warranty period, do you think? Is that what's happening?
No, the part. So what they did, they replaced the oven element, which is the part that heats up the oven, obviously. And they said there's a 12-month warranty with the part, but actually the part failed, so they had to replace the part, but they charged me for the labour for the part.
Yeah.
Doesn't sound right, does it?
No. They completely breached, and I think a lot. So what I would do is just reach out to the business and let them know, because maybe some businesses just kind of just forget these things. So if you draw their attention to it, say, look, Australian consumer law absolutely protects this case, and he shouldn't be charged anything, because the seller has the option to either replace it, repair it, or give you a refund, right? So they chose to repair it. They have to do it at their own cost with no charge for parts or labour if it's in that statute warranty period. Yeah. And then, look, there are other options if they don't play ball, is you can go to consumer protection. Some of our listeners haven't had a lot of success there because consumer protection doesn't really, all they do is mediate, they don't make a ruling, or you go to the magistrate's court and sue them, and it's a hands-down win claim there.
Yeah, all right. Mark, does that help?
Great. That's a great help. Thanks very much, Nick.
Cheers, mate. Don't pay it, I think. 133 882 is the phone number. Do you see enough police around? No's 81, yeses are 19. If you'd like to speak to Nick Maruchak, you can. The phone lines are open. 133 882 is the number. I'll be back with you in just a moment. Have a couple of calls, and we've got a text from Andrew. Andrew, we hope to get to your text because that is extraordinary if that is happening. Stay listening, listeners. G'day, Martin.
Yeah, I went to King's on the 5th of January and I spoke to the salesperson there about some solar batteries, 2 of them. And I said, I'm not sure if they'll fit, but can I rain check the sale price? And he said, no, they are today's price. And I said, well, can I bring them back should they not be suitable? He said, yeah, no problem. Bring them back. And so I took them home that afternoon and they wouldn't fit where they were supposed to go. So I took them back the very following morning at 8:30. So I had the batteries a couple of 15 hours. And they said, yeah, we can process your credit claim. And they did. And they said, oh, well, that'll be a 10% administration fee. Mm. And I went, what? That was $358. That's $35.80. Mm. And then they said, I said, well, here's my credit card. Please put the money back in there, the balance. And they said, no, you get an in-store credit. And I said, well, there's nothing else I want to buy. Mm. And they said, oh, well, you'll have to ring the credit team. So I did, and waited 11 minutes for them to answer, and they said the same thing. And I said, he said he's not authorised to credit it. And I said, well, send me to your manager, I'll talk to him. And he said, no, you'll have to write a letter. So I wrote a letter. I spoke to the ACCC and they said give them 10 days and then go to the Consumer Protection. So I wrote them and they never responded until about a week ago saying, sorry, we did not meet your standards or whatever. And the ACCC is still dealing with them now. But they said, our return policy is clear. It's on your invoice. And I said, yeah, that's emailed to you and it's after you've paid for it.
Mm, yep.
So, look, Martin, I think you've got the case is simple, right? I think it's generally if you buy something, you can't return it if you change your mind unless the store has a policy, right? So that's kind of the general law. No right to returns unless it's broken or they allow it. But in your case, they made a representation. They made a representation that you're allowed to return it. So they're bound by that representation of the store clerk. So whatever he says, they have to stick to it. So under Australian consumer law, you have rights to basically the return as represented to you. And you can go to Department of Consumer Protection. ACCC is not going to really be helping you. Or you can go, you can write to them and maybe fill out a Magistrates Court consumer trader claim. Just go to the Magistrates Court WA website, fill it out, and say, look, if you guys don't pay me, I'm going to file this. And you would argue they made a representation to me or misleading, deceptive conduct as your right to get back your money.
Great. Well, that's good to hear. Thank you so much.
Thanks, Martin. Good on you, mate. Interesting. G'day, John.
G'day. I run a business and I've got a number of invoices I've sent to some clients that are under $1,000, and I'm having trouble. Well, they just refuse to respond to my emails, phone calls, and so forth. But if I summons them to court, get a bailiff to summons them to court, then how can I get that expense of the bailiff fees, court costs, and magistrates fees pushed onto them and not onto me? Because once those fees, I have to pay. If I have to pay those fees and then and the magistrate considers that they should pay me, and those guys pay me, it's almost like not worth my time chasing for money under $1,000.
Yeah, good point.
How can I turn that around so that they pay my expenses to get the money off them?
Yep. So claims under $10,000, you can't recover your legal costs, but you can recover the court filing fee and the bailiff costs, right? So those costs of the filing fee, whatever it is, plus the bailiff costs of serving it on them, you can recover. So what normally happens is you have to pay that up front. The bailiff will serve them. Then you go to a pre-trial conference, which is a mediation. You have a negotiation trying to settle it. If you can't settle it, then you go to a trial. And if you win, you will get your $1,000. and you will also get those extra expenses back. But you can't, if you do engage a lawyer, which is not worth it, you don't recover those costs. But if you have a slam dunk case, there's no defence, you can do something called summary judgment, which is you fill out some forms, an affidavit, and you tell the judge, hey, this case is not even worth going to trial. I should just win and here's my story, and they'll read it. And if there's no defence, they'll give you judgment. And when you get judgment, you will recover those costs later on. But, you have to go through a bit of effort and jump through some hoops there. And whether it's worth your time is another question.
Does that help, John, that separate process?
Yes. What was the second system you mentioned, though? What was it called?
A summary judgment, right? So summary judgment is when you serve them, there's two things. If they acknowledge it and they defend it, then you can apply for summary judgment, which is basically telling the court they have no defence. And that avoids the trial, because otherwise you have to go to trial and they'll take a year and it's painful. Look at summary judgment.
Thanks, John. Cheers, mate. We've had a text, and if this is true, this is extraordinary, from Andrew. My company makes employees pay up when the till is down or for missing or damaged stock. 1.5 billion per year turnover, national company, 110 stores, 1,500 employees. Nationwide, staff are told they have to pay from their own pocket for discrepancies or mistakes. They've been doing this for years, apparently. This doesn't sound good, right, or fair.
It's not fair. So if this is basically a breach of the Fair Work Act. The Fair Work Act says you can't deduct from employees' wages anything. There's a really strict restrictions on that, so we'll definitely breach the Fair Work Act there. I would give the Fair Work Ombudsman a call, have a chat with them, and then you would write to them and recover all the money that's been paid. So in the past, basically, if there's theft, then if the employee stole, that's a different story. But if the till is down and making the employees pay is absolutely not on. And I think this example is even expressly stated on the Fair Work Ombudsman website, right? So the law is you can't dock employees' wages unless you get a permission in writing or unless it's authorised under an award. So if you're docking their wages for stuff like this, then that's wrong. And if they force you to pay, you just don't pay it.
Andrew, if it's okay, get back in contact with us and let us know who it is. We won't publish it, but I'd be interested in following that up to see who that is. So let us know, come back to us, Andrew, let us know what the company is. It sounds like a retail company. Yep. Cheers, mate. Let's try and squeeze Les in. Nick Maruchak's with us from MKI Legal. G'day, Les. How you going?
Well, yeah.
Fire away, mate.
I purchased a TV, a second-hand TV that is about 2 years old, 77-inch LG OLED. Retails for about $6,000. It's failed. It's about 2.5 years old now. I reached out to LG for get it fixed under warranty, and it's definitely a manufacturing fault, and they're saying that they don't cover second-hand goods, and I'm wondering how it sits within the ACL.
Yeah, so the second-hand goods are covered under the ACL. So what you can do is, it's basically, the way it works is it's how long do you expect that TV to last for, right? So there's an expectation that TVs will probably last for, I think 5 years. So you still get the Australian consumer law will still apply to that good over that 3 to 5 year period.
Even if it's second hand.
Yeah.
Okay. So what should Les do? So
then you can write to them and notify them about
the retailer or the manufacturer.
So you write to the manufacturer and notify them of the Australian consumer law, and then try and negotiate with them, and also potentially fill out a draft claim, like I mentioned before, and then give them a call. But I can have a quick chat to you, Les, as well, because I'm off air, just to kind of help you out, because that is a tricky issue, and I want you to have success on that. So.
Yeah. All right, stay there, Andrew. Andrew, we'll have a quick follow up off air. Thank you, Nick. Well done, mate. Nice to have you back in the studio, back in Australia, back talking to our listeners, and I will see you next week.
Thank you very much.
Cheers, mate. Andrew Maruchak from MKI. He'll be back with us next week. Thanks for listening. After 11 o'clock today, we're putting the band back together. Mick Collis has decided to grace us with his presence. Stay listening.